everyone, I'm Lavanya from Lexis & Company, working as an intern. Today I'll be talking about harmonious construction. According to this rule of interpretation, when two or more provisions of the same statute are repugnant to each other, in such a situation the court, if possible, will try to construe the provisions in such a manner as to give effect to both the provisions and maintaining harmony between the two. The question that the two provisions of the same statute are overlapping or mutually exclusive may be difficult to determine. The legislature clarifies its intention through the words used in the provision of the statute. So here, the basic principle of harmonious construction is that legislature could not have tried to contradict itself. In such cases of interpretation of constitution, the rule of harmonious construction is applied. It can be assumed that if the legislature has intended to give something by one, it would not intend to take it away with the another, as both the provisions have been framed by the legislature absorbed in the equal force of law. One provision of the same act cannot make the other provision useless. In case of Ishwar Khaitan Sugar Mills vs. State of Uttar Pradesh, the state government proposed to acquire the sugar industries under UP Sugar Undertakings Acquisition Act of 1971, which was challenged on the ground that these sugar industries were declared to be controlled by one union under the Industries and Development Regulation Act of 1951. And accordingly, the state did not have the power of acquisition or requisition of the property, which was under the control of the union. The Supreme Court held that the power of acquisition was not occupied by the Industries Development Regulation Act 1951, and state had separate power under entry 2, list 3. In case of MSM Sharma vs. Krishna Sinha, AIR 1959 S395, Article 19, Clause 1, Clause A of the Constitution that provides freedom of speech and expression, and Article 194, Clause 3 provides to the Parliament for punishing for its contempt is known as the parliamentary privilege. In this case, an editor of the newspaper published the word of record of proceedings of the Parliament, including those portions which were expunged from the record. He was called for the breach of parliamentary privilege. He contended that he has right under freedom of speech and expression, which was held by the court that there is a reasonable freedom that has been given to the person, and in violation of such, their punishment shall be applicable.